policy that we have here in Massachusetts. But I think whatever we do here is going to be so much more expensive because we don't have the tax provisions to generate the income that we need. What would your one message be as we come into the fall season with the potential of a ballot question? What would you like to tell the voters of Massachusetts? Jim, you.
Okay. I'd like to tell the voters of Massachusetts that we haven't even come close to examining the impact of the legalization of cannabis to our society. Witness the medical marijuana situation here in the Commonwealth. And so at this point in time, it's a completely ridiculous concept, at least in my mind, to consider legalizing this substance. And I would also invite anybody to the Learn to Cope chapter meeting. If you want to hear real stories from parents that are dealing with this, please go to a Learn to Cope meeting. There are 23 of them throughout the state, and you will hear time and time again, my son or daughter started smoking weed, and now I'm goes from there. So I know I will.
Thank you very much.
I would just add that we know the data are very clear that perception of harm tracks in an opposite direction of youth use in particular. So those are perception of harm, perception of parental disapproval, perception of peer disapproval. The changing climate around marijuana policies have been changing those perceptions of our youth, which then track in that opposite direction, particularly in Colorado, where they've legalized, it becomes more of a social norm to use. It's not scary, the perception is that there's a reduced risk of using it, and then use goes up. So we know that, and our previous speakers spoke about alcohol use. We know that youth use rates of alcohol are higher than marijuana rates here in Massachusetts, and that is a legal substance. And so I can't believe that anyone would believe that our youth use rates would not increase with legalization when we have an example in front of us.
One more question. One more follow-up. I guess until we have the hard data about whether or not there is, number one, out there in Colorado, educated us to believe there's no such thing as medical marijuana, because the FDA hasn't done any testing on any of this stuff, because it's illegal actually. So without the statistics and a tremendous amount of resources needed to explore it, the message that we came away with as a committee was, if there's any way you can stop your state from legalizing it, don't open the door for another substance to be legal that kids could be abusing in the community. And I think as a parent of 3 children, many of the other members were parents as well, I think that was the message we came home with and convinced many of us that our mission might not be the right one. We were sent there with a mission of finding a way to implement the policy should the voters approve of it, not come back with a recommendation of whether it should be legalized or not. Morally, as a person, I know I need to urge my constituency to vote against it. So,
with the science today, I would say, with the new science coming out about the harms of marijuana and the neural pathways between the cannabinoid and the opioid, I would say that this commercializing and using a niche market user base for mass consumer, large population consumer base, we're going to be manufacturing addicts.
Yeah.
That's very concerning. So we should really get the data straight and then see what to do. But this is not a solution to our punitive drug policies. That comes with justice reform and sentencing reform. It does not come with opening up an industry that can now engineer and mass market, mass sell, and mass push marijuana in our communities everywhere. That is not a solution to drug policy.
thank you.
Thank you very much for your testimony.
Thank you very much.
Sharon Levy, Paul McNeil, and Jones.
Thank you.
want to thank the chairs, Fernandez and Jones-Turner, and the rest of the committee for inviting me to hearing my testimony today. My name is Sharon Levy. I'm a developmental behavioral pediatrician, and I'm the director of the Adolescent Substance Abuse Program at Boston Children's Hospital. I want to make 3 points, all of which you've heard in various versions today. The first is the name of the law talks about regulating marijuana and claims that legalizing marijuana will allow us better control how the product is developed. That actually is just not the history of what happens with tobacco or with any other commercialized product. And you walk down the supermarket aisle, you can see that just about every product on the shelves is new and improved as they continually get reformulated to make them more attractive. This happened with tobacco. The tobacco industry made tobacco much more harmful than it is as it grows in the ground. We already see this happening with marijuana. As you've heard, new products, new ways of ingesting it, gummy bears, candies, things that are very attractive to children, and also more and more potent plants. Allowing a commercial industry to develop will push this process forward. It's very dangerous for kids. The question has come up of whether marijuana is addictive. So as addiction specialists, what we mean by addiction is loss of control over use. Marijuana is absolutely addictive. You've heard from other people testifying earlier today that nobody's heart ever stopped because they use marijuana. That's true. Marijuana doesn't cause overdose by stopping breathing with the heart like some other substances do, but that's not what we mean by addiction. What we mean is loss of control. And every day I sit with kids and families, as you've just heard, who cannot stop smoking marijuana, whose lives are being destroyed by it, who are failing out of school, who are losing interest in their hobbies, who are breaking ties with friends, as well as family members, whose symptoms look every bit like addiction to any other substance. And finally, the third point I want to make is that in 16 years of running the adolescent substance abuse program at Children's, I have yet to meet a patient who comes in for treatment of an opioid use disorder who did not first have any substantial history of marijuana use. The two, there's no question that they go together. There's more and more science linking them together, helping us understand how marijuana primes the brain for susceptibility to developing opioid addiction. I think that will be in Dr. Monroe's discussion. Thank you.
Good job, thank you.
Good afternoon. My name is Benjamin Milligan. I'm a practicing emergency medicine physician at Community Health Alliance. I'm the chief of emergency medicine and instructor in emergency medicine for Harvard Medical School. And I would like to come here, thank you all for giving us the opportunity to speak. To pick up on the theme that was brought up by one of the earlier speakers in terms of myth busting, I would actually like to do the busting this myth that marijuana is a harmless substance. In the emergency department, we do see the consequences of marijuana intoxication, both in physical and acute psychiatric decompensation framework on a daily basis. And obviously with increased availability with potential legalization, we would anticipate to have, as they have seen in Colorado, a significant increase in acute presentation. Just to put a slightly finer point on it, the types of things that we see are people at the extremes of age, so they're very young and they're very old, with inadvertent marijuana exposures from consuming marijuana-based brownies or other substances inadvertently. In my own personal experience, I saw a 90-year-old gentleman who had far too many brownies, to the point that not only was he not able to speak, he was not able to move, and was in fact barely able to breathe. Needless to say, it was an incredibly traumatic experience for him and for his family that came with him. We also spent a significant increase in Colorado in the amount of inadvertent pediatric ingestions from the edible forms of marijuana that are available there. With a significant increase in Policy Control Center regarding these cases. And as this is a relatively new phenomenon, the medical literature sometimes lags a few years behind. I would anticipate there being significant publications coming out of the experiences that emergency departments in Colorado and many states that legalized are having with regard to see quite frequently something called cannabinoid hyperemesis syndrome, which is essentially people that smoke marijuana on a daily basis develop what is essentially intractable vomiting. They're unable to stop vomiting from the moment they wake up straight through the day and come in complete distress. And obviously vomiting can cause severe electrolyte abnormalities, which could eventually be life-threatening. And this is something that's fairly new in the medical literature as the more potent forms of marijuana have become more common. This is something that we're definitely seeing, something that has been seen more in Colorado, something we would expect to see more here. So just to wrap up, I would say that I'm someone that cares deeply about the health of my patients, and I profoundly oppose any legalization online, and I would hope that you do so as well.
Thank you very much. Are there questions from members of the panel? Thank you very much for your testimony today. Jill Becker.
Good afternoon. My name is Jill Becker, and I would like to thank everyone here to listen today. I'm here today to show my support for the amendment to the Alimony Reform Act of 2011, except for the very last part, section 4G, which in part reads that no existing surviving alimony judgment is modifiable without the consent of both parties. Consent of both parties will never happen. This is why divorce is $1 billion industry a year. Personally, I've been in divorce court since 2008 and will be for many more years, and I've seen firsthand how parties do not agree. My own legal bills have exceeded $1.5 million in the first 5 years of my divorce alone. I'm in year 8. And I've never won anything. There is no real winning in probate court. There's just the mitigation of losses. My alimony payments, in context with my surviving judgment, are in the range of millions of dollars. I stand before you here today, or sit, financially bankrupt with 0 assets, thanks to my ex-husband, who also followed me into bankruptcy court to obtain a declaratory judgment, which was granted that my alimony payments to him are not dischargeable. Days before I declared bankruptcy with more than $5 million in debt, part of the $8.35 million of marital debt that I relieved my ex-husband of, which the probate courts were aware of that I was going to declare, I was ordered that I make a $40,000 alimony payment out of a line of credit for the benefit of my multi-millionaire ex-husband. Yet, when I tried to obtain the declaratory judgment that my alimony payments ended upon my ex-husband's remarriage back in 2012, I was told that I was trying to modify the surviving agreement, and I was denied. I was not trying to modify a surviving agreement. My agreement was moot on what happens to alimony upon remarriage, and thus the law should have applied. I was simply trying to obtain a declaration, a legal determination from the courts to resolve the legal uncertainty over remarriage in our surviving alimony contract. How did I get here? Back in 2002, I married, and in 2003, I bootstrapped an international capital equipment company from a Harvard PhD thesis in chemistry and brought manufacturing to Massachusetts, a company that had revenues of $20 million. It was the perceived value of that company that my alimony payments from me to my already then multi-millionaire ex-husbands were based on. The company failed. This was a catastrophic loss beyond a substantial change in circumstances, making it impossible to perform the contract to pay my ex-husband millions from the now defunct company years and decades after the divorce for a 6-year marriage. This failure was an unforeseen event, not expressly dealt in the surviving divorce agreement, which made performance of my alimony contract impossible, and it was the countervailing equity which should bar performance of the agreement. which was depending on future business success and not its failure. The courts won't modify my surviving alimony agreement because it survives. In addition, my remarried ex-husband refuses to consent to relieving me from millions of dollars in alimony and just files complaint for contempt after complaint for contempt. In fact, he's asking the courts that if he does have to pay child support, that any child support that he owes is deducted from the alimony that I owe him, in essence continuing to pay nothing for our children. Thus, in closing, I'm asking this honorable committee to stop my indentured servitude and for those like me, and provide a favorable recommendation of amendment as written, except for section 4G, due to the above reasons. I would like to get back to doing what I'm best at, and that is being an entrepreneur and creating jobs for this great state.
Thank you for your testimony, and thank you for your efforts to jam into the 3 minutes. Are there questions from members of the panel?
I just have one. You had mentioned that you've gone for declaratory judgment. So did you try to bring the case in the Superior Court for?
We went to the appeals court, and the lower judge's ruling was affirmed.
But was it in the appeals court because of an appeal from the probate court or from the?
Yes.
Okay, but did you ever go outside of the probate court arena?
To Superior Court? No, I have not yet.
Okay, because I'm just saying, I do believe that with surviving judgments, they're no longer within the jurisdiction of the probate court, that they're like any other contract between 2 people. So I'm not sure if it might be an avenue that you want to look into to go outside of the probate family court and try it as a contract action.
The contract wasn't expunged in bankruptcy thanks to the 2005 Bankruptcy Reform Act. I mean, I could have tried to file Chapter 13, but there are limits, and the limit is only, I say only, $383,175 of unsecured debt, which alimony, not domestic support obligations, which this is not, falls into. But I couldn't declare that because I owe millions.
Any other questions from members of the panel? Thank you very much for your testimony. We're seeing the alimony reform, looks like, for, I guess, 1, 2 witnesses, and then we'll get back to marijuana. Now, I'll tell you what, I'm just going to give you a flavor. I'm going to take the next 20 witnesses are going to take us at least an hour. So I'm just going to read the name of the next 20 witnesses so you have an idea. And then you can feel free to, and I'll promise you that if you come back at 5, I'll keep going. So if I don't read you, I may not read you for at least another time, at least 4:30, you feel free to take a break. So the next groups of witnesses are Salvatore Riccia, Daniel Mahoney, Phil Coleman, a panel of Will Lazure's panel with Mike Cutler and another, with Robert Schwartz, Dr. Sean Harris, Dr. John Knight, Dr. Percy Penn Mulligan, Karen Oxy, John Sheft, John Morrissey, Jenny Tracy, Hotel, Reed, William Harrison, Tom Hurley, Steve Flider, Reginald Wayne, Regina Wayne, Janice Bowen, John Nelson, John Carmichael, Nicole Snow, Steve Hittner, Chester Chin. That's the next 20 witnesses in the staff. So figure that's going to take an hour at least. And read you. If you come back, go out, I call you in, you come back, I will give you another chance. So feel free to take a break. Feel free to stay comfortable. So next witness is Salvatore Riccia. Salvatore here? Right here.
Hi, my name is Salvatore Riccia, and I was divorced in 2007. I have been paying alimony since that time. I reached normal retirement age 66 in September 2015, and I'm retired and I'm still paying alimony. A few years ago, I learned about the Alimony Reform Act of 2011 and was excited and relieved that it passed unopposed and that the intent of the bill was to end lifetime alimony, or so I thought. So I was hopeful that I could move on after reaching my retirement age. I was devastated last year to learn that the Supreme Judicial Court interpreted the law to only apply to those with divorce agreements after March 1st, 2012. I reread the law several times and could not see how the law could be interpreted that way. I reasoned using basic logic. Why would it be filed and approved if it only applied to divorces going forward, when the vast majority of people divorced were divorced prior to that date at the time of implementation? That's the way my thinking was. It made no sense, and I was horrified it was interpreted that way by the SJC, and to think that this process could go on again. Honestly, I think we all deserve the right to retire, especially since I have moved on and been married. Alimony payments after retirement is an exceptional burden and continues the payment of my divorce. I ask that you implement the necessary changes to make the Alimony Reform Act of 2011 apply to all living divorced people and alimony after retirement or cohabitation of the next spouse, as I believe was originally intended. The language of the amendment should be very clear so there is never a misinterpretation or challenge by any decision maker that causes the exclusion of any divorced living person. In conclusion, I especially want to thank the co-chairs of the Judiciary, Representative John Fernandez and Senator William Brownsburg, and the members of the Judiciary for taking their time to deal with my issue. I ask you to vote for this amendment.
Thank you for your testimony, sir. A question from members of the panel? Thank you for coming, sir. Chairman Mohammed.
When I say thank you, I mean thank you. I've never experienced this process before, and I want to bless you all. The job that I couldn't do. My name is Dan Mahoney. I've already thanked you, and I sincerely mean it. This process is incredible. I can speak passionately about all three issues that you guys are dealing with. In 1998, I started the process of a divorce. The divorce was created based upon my wife's inability to deal with her drug addiction. At the time, I had custody of the children, and I was getting no child support. As the divorce continued, my wife began using the system. This led to a long 6-year divorce involving alimony, child support, and in fact, I had the children. This long divorce put my marriage into a term then known as long-term classification. The new alimony ruling gave me the freedom and the ability to obtain an alimony reduction. However, the judges legislating from the bench has created an inconsistency and an inability for me to obtain this reduction in alimony that the new law was created for. Consequently, these inconsistencies are going to cause financial hardship for me to ensure the right in the process of a reasonable alimony reduction. I've reached a point where I've been divorced longer than I have been married, and as I come closer to my retirement, my financial future is in the hands of the Joint Committee on the Judiciary. I plead with you to consider enforcing the laws that have been already passed and to encourage the judges to stop legislating from the bench. Recapping my story, I was married in 1983, started a divorce in 98, started in 2004. I've been paying alimony. However, I've never received any child support. The laws were changed a few years to help me seek an alimony reduction. I plead with you today to reconsider the opportunities for long-term marriage, the definition of divorce, and the definition and the length of marriages. Thank you, and truly, God bless you.
Thank you, sir, for your testimony. Any questions for members of the panel? Thank you for waiting in. Shifting back to marijuana now, Bill Coleman for the Marijuana Policy Project.
Greetings to all. It's an honor and a privilege to be testifying today with regard to H 3932, which calls for a regulated system of marijuana distribution addiction to adults within this Commonwealth. I'm working as a psychotherapist in addictions and mental health counseling in Vermont, where a similar piece of legislation is progressing through our system at this time. I'm also a tobacco treatment specialist, and it should be pointed out that there are 400,000 deaths a year due to tobacco in this country, and another 100,000 a year due to alcohol use. So oftentimes it seems as though there's a false dichotomy here taking place between the use of legal drugs and the use of drugs that are currently classified as being illegal. Now, the lethality rates of marijuana are minimal, very, very low numbers of people ever die. As far as toxicity, it's virtually non-toxic, except in extraordinary forms. At least in Vermont, we've decided that we're not going to consider legalization of edibles this year. That's been removed from our legislation. Although there was a gentleman who just, in fact, a chef from down here that just was arrested at the border just last week, smuggling enormous amounts of edibles across the Canadian border to Vermont. So whether marijuana is legal or illegal, its use has just been extraordinarily high for many, many years. Even in 1975, I can remember blue fishing and looking for bluefish and striped bass in Wellfleet Harbor, and just seeing bales of marijuana floating around as the shipment had been scuttled. Marijuana use has been used in extraordinarily high quantities for a great many years. I myself used it on a daily basis from 1972 to 1992. Haven't used anything of an illegal nature or alcohol for the past 23 years, and since then I've earned 2 master's degrees, one in mental health counseling and one in community psychology. So I can assure you that recovery is very possible from marijuana addiction or heavy marijuana use in any case, and that as far as any notions of brain damage from it or brain cells are often coated. The synapses actually are coated by marijuana when people smoke it, and eventually any reductions that you might see in IQ rates are going to be alleviated as time goes on. And as a matter of fact, for anyone who's smoking extraordinary amounts of marijuana and also drinking water with it, when the synapses are coated, there's actually a neuroprotective function that takes place with the marijuana protecting the brain from damage due to alcohol, which is highly toxic and results in quite a bit of lethality. Behavior of clients of mine who use marijuana differ sharply from those who use alcohol in some very interesting ways. Marijuana smokers who are under the influence most often exhibit lethargy, preferring to remain at home and pursue sedentary activities. Generally speaking, they seem peaceful. Their thoughts are most often run inward and they are relaxed. Because marijuana has been illegal for so long, many people mistakenly assume the behavior shown by marijuana users are much more dangerous than
Okay,
those who
sir,
take alcohol.
I did announce that I was going to hold people to 3 minutes, and so that's the 3 minutes. I see that you have a lot of material there. You certainly welcome your written submission if you wish to. I have questions from members of the panel. Thank you, sir, for coming in.
Thank you very much.
Will Luzier. Yeah, and that would include Mike Cutler, who you signed in there.
And also Richard Evans,
Yep.
part of my panel.
Yep, you're welcome.
Thank you to the panel for the opportunity to speak on this important subject. My name is Will Luzier. I am the campaign manager for the campaign to regulate marijuana like alcohol. I'm a former prisoner of the war on drugs. In 1970, I was arrested and jailed for possession of less than a quarter ounce of marijuana. The search was illegal and the case was thrown out. I was lucky. There are hundreds of thousands of citizens across this nation who are not as lucky as I was. Their access to jobs, housing, and education is compromised for life. The problem is marijuana prohibition has been a colossal failure. Recent statistics show that over 842,000 people over the age of 18 in Massachusetts used marijuana in the year previous to the study being taken. Marijuana is less dangerous than alcohol. Alcohol has deleterious health effects and leads to violent behavior and crime. Adults should not be sanctioned for using a safer substance. Unregulated and untested marijuana is sold by criminals. They don't ask for proof of age. They have other substances far more harmful than marijuana to push on their illicit customers. Marijuana regulatory way. In Massachusetts, you are 3.9 times more likely to be sanctioned for marijuana than your white counterparts. If you are black, then all the usage rates are similar. The solution: allow adults over 21 to use marijuana purchased in a tightly regulated market from businesses that create jobs, pay taxes, control youth access, and rid of the black market. The Cannabis Control Commission, a 3-member board appointed by the treasurer, will regulate the cultivation, manufacture, testing, and sale of marijuana and marijuana products, setting standards for licensure and protection of youth, security, health, and safety, packaging, including child-proofing, labeling, including potency and portioning of additives, testing for contaminants, and signage and advertising. Localities will be empowered to govern the time and place, manner of operations of establishments, to limit the number of marijuana establishments within certain parameters, and to restrict signage and nuisance. A locality will also, by popular vote, be able to authorize on-premise consumption. Taxes will be 6.25%, which will go to the general fund, 3.75%, which will go to the marijuana regulation fund, and 2% tax, which will be available to localities where retail is located. The additional economic impact of ending marijuana prohibition includes thousands of jobs created in the new industry and peripheral industries, a multitude of real estate transactions, and additional tourism. Individuals will be allowed to possess up to 1 ounce in public, 10 ounces in their own homes, mirroring the DPH regulations, and be allowed to cultivate up to 6 plants or 12 plants if 2 people are growing. Alaska, Colorado, Washington, and DC have authorized regulated use of marijuana. Similar ballot initiatives are pending in Arizona, California, Maine, Nevada, to be voted on November 8th. Rhode Island and Vermont are considering ending prohibition by legislation. Ending marijuana prohibition is good public health policy and good general policy, and it's time for sensible policy in Massachusetts. We would ask this committee to report this bill as ought to pass as soon as possible. And one other thing I would say, I've passed out a matrix for all the community members that take care of the concerns of some of the folks who came back from Colorado and point out where in the legislation our drafters have addressed those concerns.
Thank you.
Members of the committee, my name is Michael Cutler. I'm a lawyer from Northampton, and my experience is in criminal defense law, prison administration, and mental health law. And my experience tells me that the effect of marijuana prohibition has been to worsen rather than remedy the public health effect of drug use and drug abuse. As one of the drafters of this the bill that's before you, my position was not to promote marijuana, but to repair the harm of the black market. The black market harms include racial discrimination. You've heard officers, law enforcement talk about there's no problem with arrests. I can tell you that no record dispositions that get sealed leave quarry for people involved in those situations. And for 6 years since decriminalization with cultivation and distribution arrests, the rate of disproportionality and racism in those arrests between blacks and Hispanics compared to the white population has gone from, the 6-year period has gone from 4-to-1 disparity to a 5-to-1 disparity. Racism is at the heart of marijuana prohibition. No one instituted the prohibition was instituted not with regard to children or brain damage or any of these other factors. It arose entirely from racism, and the institutional record, the historical record of that is entirely clear. With regard to the other fears that you've heard, all of these addiction stories are painful to listen to, and there's no doubt that there are many addictive substances in society. But we know, as a matter of fact, a number of things. We know in Holland, where they've had 40 years of legal access for adults, that the access rate for youth is 1/2 the rate in the United States. We know that in Colorado, where there has been legalization for going into 4 years now, their death rate from opioid overdose is 1/10 of Massachusetts. We know from an American Medical Association study in 2014, tracking 13 medical marijuana states for 11 years, that the opioid overdose death rate in those states is 25% below what we have. I'm not going to take apart the problems that exist in the flawed study that is relied on by many in law enforcement, but I would say that there are 2 inconvenient truths. The first is that in Colorado, the polling data shows in the 3 years since legalization has been in effect, The spread in support of the law has gone from 10%, 55-45 in 2015, to 20%. Support for the bill has virtually, the margin has virtually doubled. It's now 58% supporting it to 38% opposed. So for all of these horrible things that we've heard about the falling legalization, those the people there are supporting it, and so is the governor, who's a former opponent. In closing, let me just suggest that this is not a fad or consumer trend, but a force of history, a force of social justice, and a force of public health. The reform opponents forget the lesson of alcohol prohibition, that the cure of prohibition was worse than the disease of drug abuse. Canada, Mexico, other South American nations are embracing full adult access. Holland, Spain, and other European nations are as well. We also have Rhode Island, Vermont, and California poised to join us. So I would just suggest that it's time for the people to change the law and the legislature will.
Thank you, Mike.
Thank you, Mr. Chairman. My name is Richard Evans. I'm a lawyer in Northampton as well, long-time advocate for marijuana law reform, and I'm the chair of the Committee of Regular Alcohol, Regulated Marijuana and Alcohol in Massachusetts. Mr. Chairman, today's Boston Globe contains that op-ed from the governor, the mayor, and the attorney general, and with that op-ed, I think we can say that the debate over marijuana in Massachusetts has finally, at long last, erupted. And I think that's a very good thing for all the people of the Commonwealth. Having come to these committee hearings for many years, I think it's great to see so many people expressing such diverse views. And I know that it's the view of all of the committee that you want the debate over the next 6 months to be informative and fair and illuminating, and I'd like to talk about that. How can we talk about this issue for the next 6 months, because we're going to be hearing a lot about it, in a way that informs the debate? I'd like to make 5 simple suggestions. First of all, let's keep in mind that it's a binary issue. It's marijuana's legal or it's not. If you embrace a prohibition, that is, if you oppose legalization, then that is to embrace prohibition. That is, if you oppose legalization, like the governor does, that means you want to keep the industry in the shadows. If you oppose legalization, like the mayor does, it means you want to you don't want this industry to pay its fair share of taxes. You don't want consumers to have protection of food safety laws and consumer protection laws. If you oppose legalization like the Attorney General, it means that you don't have a problem with people losing their housing or their jobs or their scholarships or sometimes even custody of their kids when they talk to a little class. And so let's remember that if you oppose legalization, then you need to make the case why prohibition is a good thing. And we didn't hear anybody making that argument this morning or earlier this afternoon. Secondly, as to the language we use to talk about this issue, let's please avoid this insidious fallacy that drug use and drug abuse are the same thing. The prohibitionists have been conflating those two terms for many years, and it's and of course that explains how the budgets for prohibition enforcement is so huge, because they typically define all use as a form of abuse, and this is a corruption of language which I hope we will avoid. And the term recreational marijuana, let's please avoid that too, because it doesn't take into account people who use marijuana for spiritual reasons, for enhancement of life, for vocational reasons, and plenty of others. Let's don't use bogus and discredited reports and studies like was cited in the Globe this morning. They cite in their op-ed, the year after the drug was legalized, marijuana emergency room visits nearly increased 30%. Well, if they read the report, they would have seen that emergency rooms or marijuana-related visit counted even if you broke your leg and brought in and your top screen showed some THC from a joint we smoked a month ago. So,
now that there it is. Okay. I'm planning on holding the voice in the room. It's 3 minutes. Again, we welcome your written testimony, and we know that you've got lots of material. Other questions from members of the panel? Okay, gentlemen. Thank you. Thank you. Thank you very much. Sarah Chiaravita. What organization you affiliated with?
I'm with the Massachusetts Association of Health Plans. I'm the Vice President of Legal Affairs with that. Thank you for allowing us funding.
So on behalf of MAP and our 17-member health plans, we provide coverage to over 2.6 million Massachusetts residents. We're here to offer our testimony in support of House Bill 3993. We are pleased to support this bill as it will provide the police with discretion to prosecute those individuals with opioid addiction who request help from law enforcement. And we applaud the leadership of the committee and also Representative Fontaine and the Gloucester Police Department providing a path for these individuals to obtain treatment. We believe that this initiative will go a long way towards destigmatizing addiction, helping to move away from the system of incarceration to one of treatment for those who are suffering with addiction. Member plans have been committed to improving access to treatment for opioid addiction, and we have actually been working closely with the Gloucester Police Department on this PARI initiative to help ensure that those who come through the program have a path and assistance in helping to stay on their recovery. Our members provide access to coverage to a broad range of individuals, including those on Medicaid, senior care options, individuals and employer-sponsored health plans, individuals purchasing on the connector, and individuals purchasing coverage on their own. We entered into this pilot with Gloucester because we wanted to help support through care management and data collection the innovative work of their team, and because we recognize the importance of having these supports in place for individuals as they move along the continuum of care, because detox is only the first step towards recovery. This pilot builds on all the current efforts that our health plans have been doing to support those with substance use disorder and the Gloucester Police Department. And we help to, again, support individuals as they transition towards these different levels of care. The pilot includes 3 important components: care coordination and discharge planning, engagement and outreach, and data collection. I know there was some discussion earlier about recidivism rates and tracking individuals who come through the program. That's one of the important components of this pilot. We're really able to help them track individuals and find out what happens after they leave the police department. So if these individuals are members of our health plan, we collect data on the number of folks coming through the program, where they were placed. Did they enroll in a care management program with the health plan? Did they seek services post-detox? And were there recidivism? Were there readmissions both within 7 days of the program and within 30? We're just beginning to track this data as it's made available. We did start the program in January, so we're hopeful in the coming months we'll have a lot more information to share about how this program has worked. And then once we get farther along in the process, we're hoping to actually be able to compare the outcomes from the folks who come through the Gloucester program with those who obtain services through other means. So we think this bill is important, and we're pleased to offer our support.
Thank you. Super with respect to other questions from members of the family. We look forward to hearing how your other members are.
Thank you so much.
Robert Schwartz.
Chairman Brownsberger, Chairman Fernandez, and the rest of the committee, thank you for scheduling this hearing on House Bill 4034. My name is Robert Schwartz, and for the last 4 years, my life has closely followed everything the alimony reform law in 2011 was supposed to accomplish, and that it did. Based on the cohabitation provision of the new law, I filed a complaint seeking to have my alimony obligation terminated. The complaint ended up in a probate court trial. During the trial, my ex-wife testified that she had been cohabitating with the same man continuously since 2005, and her partner testified to annual income of $189,000, and that he provided her with a vast amount of financial support. Following the trial, I was awarded a judgment that terminated my alimony obligation. She appealed. While the appeal was ongoing, the Supreme Judicial Court issued its decisions of January 2015 that had the effect of canceling the cohabitation retirement provisions of the alimony reform law, but only for divorces that preceded March 1st, 2012. As a result of the SJC decisions, my judgment was vacated and alimony was reinstated retroactively. With that reversal and its retroactive application, 44% of my gross income now goes towards alimony, and the rest is almost totally consumed by ordinary living expenses, taxes, and debt payments. I'm 63 years old, I own no property, I'm no longer able to contribute to my IRA, and my assets have been greatly depleted by years of litigation and tens of thousands of dollars in legal fees. I must continue working indefinitely, all the while paying alimony, and can't even foresee a time in the future when I can retire. In contrast, with the alimony she receives from me and the financial support provided by her partner, my ex-wife effectively has a six-figure income without having to wake up to go to work in the morning. As a result, she continues to accumulate assets that, again, according to her trial testimony, are nearly 3 times my own. She and her same partner continue to live in the condo in Wayland that they purchased in 2005 for nearly $700,000, about 50% more than the marital home we lived in. I'm the prototypical case of what the alimony reform law was expected to fix. In fact, did fix until the SJC rulings. Having closely followed the legislative process that led to the enactment of the alimony reform law, including the work that began with this very committee, I don't believe the SJC decisions were consistent with either the intent of the law or the public policy issues that the law was supposed to address. You now have before you House Bill 4034, which contains clear and concise language that will restore the alimony reform law to what this committee, the legislature, and then Governor Patrick all intended it to be. I urge you to give it your favorable recommendation and send it out to the legislature for its approval.
Well questions from members? Clear testimony. Thank you. John Knight, Sean Harris. Nice to see you, Dr. Knight.
Good afternoon, and thank you for this opportunity to express our strong opposition to H. 3932. So my name is Kim Harris. I am a research scientist in adolescent health at Boston Children's Hospital in adolescent health. And I also co-direct the Center for Adolescent Substance Use Research with Knight, and I lead the neuroscience research arm for our center. Prior to writing at Boston Children's, I worked for the Massachusetts Department of Health, overseeing adolescent health and school health-related projects, research projects, and while there, I helped provide data on adolescent smoking rates for the Attorney General's office for their successful lawsuit against the tobacco industry that ended in this court settlement. And I just find it so dismaying that we as a state are here potentially poised on the threshold of legalizing another addictive substance that could derail their lives and cause societal harm. I've spent my research career of nearly 20 years dedicated to the pursuit of knowledge regarding how to promote healthy and successful development of our youth into adulthood. Our youth are, after all, our Commonwealth and nation's future and our greatest natural resource. I have come to see through those years, both as a research scientist and as a community member and as a parent, that substance abuse is the greatest and most frequent threat to the healthy development of our nation's youth. The high cost of addiction, which we've heard a lot about, which has likely affected every single person in this room, either directly or indirectly through family members or friends, almost always has its roots in adolescence. So 90% of adults with a substance use disorder started using during adolescence. Today, the potency of marijuana and therefore its addictiveness and potential for harm is dramatically higher than 2 decades ago. That's published research from the University of Mississippi that is charged with samples every year. Today, marijuana is the leading cause of adolescents entering substance use treatment, accounting for nearly 90% of teens entering substance use treatment. We now know that teens are more susceptible to developing addiction because their brains are still highly plastic or sensitive to change because of critical development that continues well into the mid-20s. A large body of research now shows that exposure to substances such as marijuana, tobacco, or alcohol during this highly sensitive period can permanently alter both structure and function of the brain. So my colleagues in the field that are looking at the social experiment going on in Colorado and Washington, they are publishing alarming data showing a much greater increase in marijuana use in those states, even with the minimum legal age being 21. So given this data, I strongly oppose legalizing or repeating the same mistake that we made with tobacco and legalizing recreation.
Thank you for the testimony. Dr. Knight.
I've been a pediatrician at Boston Children's Hospital now for more than 25 years. So I've seen a lot happen during those years. Dr. Harris came to work with me about 15 years ago. She has a PhD in epidemiology from Johns Hopkins University. She's an epidemiologist and a study methodologist. I was beginning a research career because I was offended by seeing needless death of teenagers and thought something had to be done about it. I always tell people that in our partnership, Sion is the brain and I'm the pretty face. Everybody laughs when I say that, but a grizzled pediatrician, you know, I've seen a lot. I'll tell you that I've been a lifelong student of scientific literature that has to do with this problem. And it's been my privilege to lead studies of prevention and early intervention that have had worldwide impact over these years. There are 4 indisputable scientific truths that I would lay before you. Number 1, addiction is a pediatric disease. That's why I'm here as a pediatrician to talk to you today. It has its onset during adolescence. Nearly 90% of people that require addiction treatment start their use when they're young. And the earlier the use, the greater the likelihood that their brains are changed permanently in a negative direction. They have quadrupled the risk of developing addictive disorders, major depression, anxiety disorders, and psychotic thinking. Our rates of schizophrenia could soar. Marijuana has a fairly favorable risk-benefit ratio for adults with pain and other unpleasant conditions, but it is a neurotoxin for children. Legalization will expose more children to this risk. Those are the scientific facts. Why did I come today? You're hearing so much testimony. You know, I don't need to just bang the same drum. I came because the role of a pediatrician is to give voice to those who have no voice. I'm here to speak to you about the bereaved family members that have sat in my office over the years that lost their children, brothers and sisters, to addictive disorders. I'm here to tell you that listening to a mother describe having to sign papers for her daughter to be taken off life support so her organs could be donated to others because of an addictive disorder that began with cannabis use as a teenager breaks your heart. Those voices I leave with you today.
Thank you, Dr. Thank you for your timely testimony. We'll ask a question from the panel. Yes, please.
Hi, my name is Julie Johnson, and I'm a substance use researcher by training. However, I'm currently on maternity leave, and at 12 o'clock this afternoon, Dr. Knight, my former mentor for many years, had called me and said this was going on today. So what did I do? I rushed to get a babysitter, and I managed to find a suit in the house we just moved in literally 2 days ago, and I got here today. Why? Because I am so passionate about what is going on here today. Career-wise, I may deal with statistics surrounding the marijuana laws and adolescent substance use at the macro level, but I want to divert from the academic research discussion for a little bit today to discuss why I made it so clear to get here in time. 2 weeks before my 16th birthday, my then 19-year-old brother, Jeff, called me one night late after partying with friends for the last heart-to-heart conversation I'd ever had with him. He came clean about his extensive self-medication of his anxiety and depression with alcohol and marijuana. We talked for 3 hours, but he'd already taken enough drugs to take his own life. This was his decision. Jeff started using marijuana as a young adolescent, probably around 13 or 14 years old. And later transitioned to harder drugs that eventually took him from us. Since losing one of the most internally beautiful but suffering person, I have wholeheartedly made it my life mission to understand why and prevent this heartbreak to other sisters, families, and friends of other Jeffs. Marijuana is considered by many to be a benign drug, but there is a plethora of evidence suggesting acute and long-term consequences for adolescents, including both structural brain changes as well as future healthy education and employment opportunities. Alcohol and marijuana are the most used illicit drugs in the U.S. and Massachusetts, both illegal for adolescent use. Patterns and perceptions of adolescent use are often established in adolescence. Legalizing marijuana may change not only the decrease the price and increase access to, but it may also change the perception of harm, which epidemiologic research consistently shows perceptions of harm are inversely proportionate to use. Research shows that this liberalized perception is increasing, which is highly concerning to me personally and as a researcher. Adolescence is the maturation period between childhood and adulthood, where the brain undergoes important neurological maturation processes, which makes their brains more susceptible to environmental influences. Additionally, given the opioid use epidemic in Massachusetts and New England, increased marijuana access and availability in the state concerns me for the co-use of substances, starting with the most commonly used substances, alcohol and marijuana, like my brother had. Adolescent co-use substances for varying reasons, including policy changes such as legalization, drug availability, price changes, all of which will be impacted if legalization is passed. I personally and professionally see this as a dangerous and premature slippery slope.
Thank you for your getting it in 3 minutes. Good job. Yes.
I'm Jody Hensley, and I'm here as a resident of Westborough, Massachusetts. I speak today as a private citizen and a mother and an elected school committee member. I've submitted my comments in writing. I would ask you to look at those because I have much more than 3 minutes here. I came to speak today on industrial regulatory capture, on the compromise of home rule for Massachusetts cities and towns, but I will spend my time on education because no one else has spoken to that yet today. I want to talk about the impact of marijuana legalization and commercialization on education and on our youth. Colorado now has jumped to #1 among the states in youth use of marijuana. It's jumped to #1 in every age category, including young adults and adults, but it's #1 for youth. And it's difficult for a parent, much less an elected school committee member, to ignore a headline out of Colorado that reads, "Colorado educators concerned about pot in schools," which appeared in the Denver Post just last fall in October. The article says that in Thornton, Massachusetts, school officials gathered and educators packed a conference room, taking detailed notes and heaving sighs as they learned about what authorities are calling the #1 issue in Colorado schools that they face today, and that's marijuana. I visited this summer with a cousin who's a teacher in marijuana, and he told me that his superintendent said the only thing marijuana legalization has brought to Colorado schools is more marijuana. So just this past February, I called this superintendent, Dr. Harry C. Bull, who is the superintendent of Cherry Creek School District, which educates 55,000 students, has a staff of 9,500, and serves Greenwood Village, Aurora, and Arapahoe County in Colorado. He indeed did say that. There has been no funding coming to his school for marijuana sales, but he has seen a clear increase in the number of third drug offense violations, which have resulted in student expulsions from his school. Kids in his school do not get expelled for a third alcohol offense. It's marijuana that they cannot seem to quit, even though the consequences for them are dire. And depending on what source you look at, this represents either second or third stage drug addiction. So that's what's happening in schools. And another story from Cherry Creek is that there are parents now who either smoke at home or smoke in the car on their way to school. This speaks to the marijuana normalization of adults in Colorado using 200% the national average. In several instances, backpacks had to be placed outside the child's room because it was permeated with the odor of marijuana, and parents had to be told that their child was not alert for learning due to secondhand marijuana are contact high. We've learned from our doctors what's happening with marijuana exposure to the young brains. These are the littlest people among us. These are elementary school students who are not showing up under the influence of marijuana. I highly recommend that you read the rest of what I've offered in my written testimony, that you oppose this act vigorously.
Thank you. Yes, ma'am.
Yes, my name is Crystal D'Angelo. I'm a parent facilitator for Learn to Cope. I also work for a community service agency that I get to go into families' homes. I work with children who have serious emotional disturbances. Mostly I'm a single mother. This journey started for me 6 years ago. My son Brandon started smoking marijuana at 14, which ended up leading him to, I sought help through his primary care physician, through the legal system. I actually sought out to hospitals and the Department of Children and Families to kind of get help from our son, and I could not get help. My son, he started using heavier drugs. He went from marijuana to PCP to opiates. He ended up in 3 detoxes for adolescents. He went into a 90-day program, which he was kicked out of. And then in turn, he went into a residential treatment program where he was for 8 months. He maintained sobriety. He returned home back into the community, but let me say that the community that we lived in before, there was a lot of marijuana use, and in our apartment, I saw a younger son that our neighbors were smoking so much marijuana was coming into our home. It was a violation of my lease. I tried to do everything to get it to stop, but the police would refuse to do anything. The comment was, if you're unhappy with what your neighbors do, buy a house. So with my son coming out of a treatment where he has almost a year of sobriety, I had to move. So I moved to another neighborhood. He wanted to go back to regular high school. Within a couple months, he had relapse and he was back, and then he was on the run and he was missing for a year. He has now since been out. He is active. His go-to is marijuana, but he is a shell of the person he once was. This was an athlete. He was creative. He had A's and B's. He was on the honor roll. Now, for 6 years of using marijuana on a regular basis, he's anxious, he is depressed, he is suicidal, he rages if he's not getting high. He has hallucinations. His short-term memory, I could have a conversation with him, and within 10 minutes later, he has no recollection of this conversation. This was a young man who took very good care of himself, was impeccably groomed, was very smart. Now he'll go months and days, he'll go days without showering, taking care of himself, doesn't eat. He has been homeless, living in his car, and he can't keep it up. This is the effect it's had on me. Now, where I go into people's homes and I see families, I have a lot of clients, and the ages are 12 to 14-year-old young children who are smoking marijuana because it's not harmful. I'm in the judicial system with the juveniles. I'm helping them get mental health care. I'm helping them with detoxes and everything else. It's everywhere. I have a 15-year-old who's in high school. He goes, Mom, it's at the bus stops. We have police at the bus stops trying to do this. It is absolutely everywhere. He goes over to people's homes. He comes home. He reeks of marijuana because parents are smoking it. So then I drug test him. He comes back clean. That's my youngest. This has completely torn my family apart. I have a beautiful 20-year-old that I have lost 6 years of his life because of marijuana. And I beg you, please don't legalize this here because it's only going to get worse.
Thank you for your testimony. Questions? Representative Roy.
I just wanted to go to the research that you talked about the adolescent brain. We heard testimony earlier today about the brain, the adolescent brain having some sort of plastics that will, can you address that?
Yeah, sure.
Talk about that.
Yeah, so this is really quite a paradigm shift in science that we now understand that really crucial development is going on in the brain through adolescence. The middle of the third decade. So what that means is that while the weight of the brain doesn't change, like after about 12, there's a lot of sculpting of the brain that's going on, both pruning and myelinating of neurons to make the brain really work very well in an efficient, integrated way. And that's the developmental process that can really get derailed by social substances. And what we're realizing is that that is actively going on in adolescence, and particularly in a part of the brain called the reward pathway, which is the part of the brain that is involved in motivated behavior, and that is hijacked by drugs. And so because of the rapid development of that part of the brain during adolescence,
that could be one of the underlying causes of greater addiction vulnerability of this.
Is that reversible?
I'm sorry?
Is that reversible?
So that research is still fairly new in terms of what is neurorecovery, and we don't really know that well because the longitudinal studies haven't been, done.
Marijuana dependence, which is the most common reason for admission to addiction treatment during adolescent years, is the most difficult to treat. It's far easier for us to treat someone with opioid dependence. We use buprenorphine maintenance, and so teens become treatment seekers. It's no fun being terribly drug sick, and so they really become more invested in treatment. They may have relapses, but they keep coming back. Where it takes 3 to 6 months of time away from the drug before the thinking can clear up enough, so that teens who are dependent on marijuana, it's like they can't process the information that's going on in psychotherapy. They just don't have the cognitive wherewithal. They're not there for the language and the emotion and the discussions. So scientists at the National Institute on Drug Abuse discovered something called the endocannabinoid system in the brain. It's poorly named because our brains were created to process marijuana, but the system uses a neurotransmitter called anandamide, and THC is a cogener of it. It's like a counterfeit or a lookalike, and it binds to those sites, and then it doesn't function the way that it's supposed to. The first decade of life is primarily growth of neurons, the gray matter of the brain, all the centers that do processing. The second decade is connections, the white matter of the brain. You can't function as an adult, you can't graduate from college unless all the centers of your brain can transmit data at light speed so that 5, 6, 10 centers can be involved in processing a complex problem. You can't be emotionally healthy unless you can integrate data from sight, sound, your memories at instant speed. And so that's what cannabis does, is it slows down those connections and interferes with high-speed data. And so you have emotional unhealth, inability to learn, loss of IQ points over time. That is responsible for what we all see. People that start smoking early and continue, essentially sit home, in their sweatsuits and watch TV and talk about great revelations and changing the world, but they can never seem to get away from the TV or their earbuds.
I just want to actually quickly say something about THC and memory. And so there's a part of the brain called the hippocampus, which is the command center for learning and memory formation. It turns out that the hippocampus has a lot of these cannabinoid centers. So THC really hits the hippocampus a lot, and THC has this dampening down effect on neurons in the hippocampus, which basically dampens down the activation of the neuron below the level needed to trigger memory formation. So this is where the effect of marijuana on short-term memory is rooted. But also over time with chronic THC exposure, what happens is those the connections amongst the neurons in the hippocampus actually get pruned away because the brain has this use it or lose it property where the connections that are used are kept and strengthened, but the connections that are kind of dampened down and not used are pruned away. So then it gets harder and harder to learn new things as there's acclimation to THC.
I'm the chairman of the Committee on Substance Abuse for Massachusetts, and I just want to say that on behalf of the pediatricians in your state, and there are many of us, we thank you for the time to represent children before you. And as our leaders, we trust them all to do the right thing for children and adolescents in the Commonwealth.
Thank you for your testimony. Ben Milligan, Jody Hershey. Ms. Ross, Ben, you should already testified. Okay, so Ben Milligan and Jody Richard are not here. Karen Hodson.
Requesting that Steve Hittner and David Lee join me as a panel, if that's acceptable.
Sign up as a panel, we will cut you a break.
Hey there, my name is Karen Hoxie, I'm here to speak in support of House Bill 4034 to reform alimony. My perspective is that of a second wife. I'm married to a man who was sentenced to lifetime alimony in 2004. Personally, my former husband decided he didn't want to be married to me anymore 15 years ago. I waived my rights to alimony, worked a second job, pulled myself up by my bootstraps, supported my children, with no help, essentially, from my ex-husband. Fast forward a few years, my husband, John, left his wife after discovering she'd been unfaithful for almost 30 years with other women. No minor children of the marriage. I testified several times in front of various formats here. You might remember me, I promised lobster to everyone, but because...
We like that, there's too much, too valuable.
Well, you could get 4 per person for $50. And I thought we were going to be able to make good on that promise when the Alimony Reform Act passed in 2011. We went to court based on the fact that my husband's ex-wife was cohabitating. Unfortunately, she had adult children who were willing to testify that she was living with them. So we really had no case, and that will continue. So the only out we have for this is the retirement clause. My husband gets up at 4 a.m. every day to do his job, support our family. She received hundreds of thousands of dollars in 401k. When we did go back to court, it was shown that 100% of the money that he sends each month is sent directly, she puts directly into her investment account. She does not need this money to live off. She vacations constantly. Her girlfriend of 14 years is a felon who was convicted in 2013 for a faked shooting while she was driving an MBTA bus. You can Google it, it's pretty interesting. I worked 2 jobs as a nurse. I attained that degree at the age of 44. Within 2 weeks of graduation, I was able to get a job with a great starting salary. There were people in my class who were graduating at age 60, so there's no reason that his ex-wife couldn't have done a similar thing. She already had a pretty good career established. I love my jobs. I didn't choose to be a nurse, it chose me. I work really long hours. I come home, my feet ache, my back ache, and sometimes I cry the entire way home, a 1-hour commute, because my heart hurts for what I've seen during my shift. I wouldn't change it though, but if anyone here can justify why I should continue to work into my 70s so that my husband can afford to pay his ex-wife alimony, I would be happy to listen. She retired at the age of 47 because she could when she was awarded lifetime alimony.
Thank you for your testimony. Who's next?
My name is Steve Hittner. I'm the president of Minnesota Reform. We've worked hard to work with the legislature with the Alimony Reform Act of 2011 passed. I was actually linked to the Alimony Reform Task Force. The act was written by what I feel was the smartest minds in the state, not including me. I'm not a smart guy. They wrote a very clear, very consistent law. The legislators were all educated to what the law meant. People spent hours getting to know the legislators, the reps in the Senate, to explain what the law meant. The law was passed unanimously in the House and the Senate, which I believe went through the training Judiciary unanimously also. The speeches when the law was voted on in the House and Senate playing with the low end. However, the SJC, in their infinite wisdom, decided that what we meant we didn't mean. The word shall meant maybe. They used words that were put together the way they wanted them put together to do what they wanted to do. I normally speak very positive about things, but here's the case where I have to say it the way it is. I spoke to lawyers all over the Commonwealth. Every lawyer I spoke to says they got it wrong. I spoke to judges. Judges have written in a ruling that they believe that the law was clear, but they said about having overturned the ruling that they made. It's destroying lives right now, causing people angst and money that they shouldn't have to pay to litigate and relitigate. All I'm asking you folks to do is to follow the law the way Judge Scalia usually passed it. Judges should be ruling by the law, not interpreting the law to the way they want it to be. And I feel that judges should not be legislating the bench, as they did with the SEC did with this law. And as a member of the task force, as a very strong supporter of the cause, there can't be two different classes of citizens. There has to be the same law applies to both. I ask you to push ahead age 40, 43 as quickly as possible for the benefit of the Commonwealth, citizens of the Commonwealth. Thank you, John Fernandez, for chairing this task force. Thank you, William Valverde, for chairing this, co-chairing this with him. And I hope this is
He's doing it all.
Thank you.
May it please the committee, my name is David Lee. I have been a divorce lawyer for 43 years in Boston. I was the co-chair of the Massachusetts Bar Association, Boston Bar Association Task Force on Alimony Reform, and spent over 2 years studying alimony around the country and also the difficulties in dealing with alimony in Massachusetts. Come up with a white paper which was endorsed by both the Mass Bar Association and the Boston Bar Association. And then I had the pleasure of working with Senator Canderas and Representative Fernandez on the legislative task force in addressing the alimony reform. The SJC got it wrong, in my view, in their decisions in Sheen, Rodman, and Doctor cases. They don't accurately reflect what it is that the intention was of this joint body as it was presented on the floor of both houses and unanimously passed. They hung their hat on the use of the term prospective in Section 4 of the Alimony Reform Act and said that means it only applies to those who get divorced in the future, rather than recognizing that prospective meant that you couldn't go back and collect alimony that had already been paid if in fact there had been cohabitation or an earlier retirement event with respect to people who had already been divorced prior to enactment. They also overlooked Section 6 of the Alimony Reform Act, which very directly indicated that it was intended to apply to those who were divorced prior to enactment in March of 2012. The impact of the SJC decisions has been to create two classes of citizens in the Commonwealth of Massachusetts based merely upon the date on which you were, in fact, divorced. And this is particularly so with respect to the two elements of cohabitation and the element of retirement age. The bill 4034 fairly brings these two sets of classes into parity. Those who were divorced before March of 2012 and those divorced after 2012, while preserving the very important element in any judicial process, and that is discretion and the ability to deviate when there's good cause to do so. Support for this bill is essential, and it will avoid discrimination against a class of people who had no intention of being a separate class of people. And I thank you for the opportunity to be able to speak and ask that you all support this important bill.
Thank you for delivering your testimony so well. And other representative
It's going first. I want to thank you for coming back. I do remember you. I do remember your testimony. testimony, and I didn't get the lobster, but I fully supported the bill back then, and I guess I just wanted to say we're sorry, because I felt that when the legislature passed it, it was fairly clear. And I think from my own perspective, I'm not here to testify, obviously, but I echo your sentiments of that it has absolutely wreaked havoc on the system, because there were judgments that have been overturned and put people in really difficult positions, spending a lot more money on litigation to get it right. And you have situations where people are getting alimony where we had fully determined they no longer should be having to pay alimony, or they should no longer be recipients of the alimony. So I want to thank you for coming back again, and I'm sorry that it was misinterpreted. Thanks.
Yeah, thank you. I want to thank all three of you for coming in and testifying. And I will just want to record saying I didn't get any lobster. I'm not looking for any lobster. I'm not looking for any food. But I want to thank Steve and Dave for their work on this. The task force did work for a couple of years, and the attorneys who participated, non-legislative attorneys who participated, contributed an awful lot of very valuable time, along with Steve, who's contributed so much as an advocate over many years to try and craft this bill. And I just want to, echo what we said back then. We worked for 2 years on this because getting two attorneys to agree on language is difficult. Getting 6 or 7 is nearly impossible. But we agreed that we would only put a bill out if every word, every paragraph, and the entire sections were agreed to unanimously. We did, and that's when it went through the legislature unanimously as well. I have a great deal of respect for the courts. As an attorney for 33 years, the work that they do in fleshing out the legislation that we pass is important. It's historical, and I respect it. And we took our time before acting on this to make sure, in fact, that we saw how this was going to play out and understand its impact. And I think to a person who was on that task force that came back together again to work on an amendment, we again unanimously agreed we needed to do something without saying the SJC got it wrong. The manner in which it's being interpreted is not consistent with our intent. So that the SJC got it right on the way we wrote it, or the way we talked about it, is different than whether they got it right on our intent. And I do think it's important when you intend something different, then you make it clear what that was. And I think that this amendment seems to do that. And I appreciate, again, your support and for that contribute to making this amendment possible, and we'll see where it goes from here. But thank you very much for your time.
I have a little information report.
We got it.
I believe John Sheff has already said something. John Morrissey? John Morrissey. There you are, Dave.
My name is John Morrissey, and I'm here to express my support for House Bill 404. I've been paying alimony now for decades for a mistake that I made when I was 18 years old. The day that my ex-wife and I agreed to separate, I had thought it was an amicable direction and that we were going to be friends, one of those. And it turned out that that day, while I was talking with her, after that conversation, she went and resigned from her job. We both worked in the same industry, almost side by side. She had the same opportunities that I had. We're both college educated. She went and quit her job, making her income zero. My income was placed against that at, let's just say, 100. I had an attorney that convinced me that, you know what, you have a potential here to lose 50% of your income for the rest of your life, and I was scared to death. And so I signed an agreement that was less than 50%, but very significant, altered my life, and my new wife, my blessed new wife, who you just heard speak earlier, it altered her life as well, and you heard how it has changed her life. I feel that when the law of 2011 passed, there was this tremendous weight that was relieved off my wife and my shoulders and our entire family. We have a son, 9 years old, and we thought, you know, I'm finally free. You know, this mistake is over. The tragedy is over. We're just going to have our own lives here now. And then, as was just articulated a few moments ago, obviously that law was not interpreted by the judges in the fashion that it was written for, you know, many reasons, and I understand why. So I'm here to ask for two things. I want the opportunity that if my ex-wife is making more than the amount of money that I'm making and living with someone else and has a house better than mine, an income better than mine, that I be released from the involuntary servitude of paying her for the rest of my life, and two, that I simply be allowed. My wife mentioned the fact that she works 2 jobs, I also work 2 jobs, that we be released to the point where we could work 1 job and have the opportunity to retire, just like anybody else that lives outside of Massachusetts. To be able to retire at age 67 is my goal, and I ask you for that. Thank you.
Thank you for your testimony, sir. Questions from members of the panel? Seeing none. Jen Tracy, MRI, Ayala,
Good afternoon, Chairman Brownsberger, Chairman Fernandez, and members of the committee. My name is Jen Tracy. I'm the Director of the Office of Recovery Services for the City of Boston. I'm joined today by Deputy Superintendent Norma Ayala and Lieutenant Detective Brian Ryan from the Boston Police Department. Together we represent Mayor Martin J. Walsh, who, as you know, is a committed and vocal opponent of this policy proposal. You have heard from the proponents today that legalization of marijuana is harmless, that the tax benefits to the state will outweigh the negative impacts, and that there will be few people in the criminal justice system who legalize marijuana. We think these arguments obscure the true impact and motivations of the marijuana legalization movement. The truth is, as you have heard, in states where marijuana has been legalized, the negative impacts of legalization far outweigh any positive benefits to the state and its residents. Instead, it enriches a handful of marijuana entrepreneurs at the expense of public budgets, including those of our cities and towns. So we echo and share all the concerns around the health impacts on youth, so I will state that it's in the testimony, you can read it and go into a few things on it if we have marriage. The way the language of this legislation is constructed limits the ability of cities and towns, and particularly their legislative bodies, to regulate these businesses or prevent proliferation of marijuana shops in our neighborhoods. Boston City Council recently took the step of limiting the number of marijuana retailers in our neighborhoods by passing a half-mile buffer zone around existing marijuana facilities, so that these retailers will be evenly distributed among our neighborhoods. This legislation would render this proactive step null and void, as it requires cities and towns, in the absence of a referendum vote, to accept the same number of marijuana retailers as is equal to up to 20% of the existing retail alcohol outlets. In Boston, that means that we will be forced to accept and cite up to 50 marijuana dispensaries in our city, which, based on current zoning, would be concentrated in our commercial downtown and Main Street zones. Cities and towns and our residents should not be forced to shoulder the impact of this new industry and be required to accept a certain number of businesses. This flies in the face of common sense and the long-standing tradition of home rule of the Commonwealth. I will now turn it over to Deputy Superintendent.
Good afternoon, probably good evening almost. I know you've heard so much testimony today, and I'm just going to briefly talk about a couple of things.
You might want to pull the microphone a little so people
Sure.
can hear you, but it's
Okay.
not necessarily.
So, the Boston concerns regarding the public safety, impact of recreational use of marijuana, would it be legalized in Massachusetts? And I want to talk about a couple of issues. First, while proponents of this legislation believe we will see a reduction in the number of individuals arrested for drug use, the legalization of marijuana is likely to result in an increase in other related crimes. And people have talked about, carjackings, home invasions, commercial robberies of these stores. The sale and use of marijuana remains illegal at the federal level, so it makes it difficult and risky for financial institutions to do business with marijuana establishments, even in states that have legalized their existence. For the foreseeable future, the production, distribution, and sale of marijuana will remain a predominantly cash-only business. Again, commercial robberies, people will know that there was a lot of cash on hand, or they will take it home. They could be carjackings while they're transporting this cash home or at home. And then you have their families that will also be victims in this. This increases the likelihood that retail marijuana stores with a large product inventory and cash on premises will be targets. In Colorado, burglary was the highest crime related to the retail sale of marijuana. The burglary rate of marijuana retail stores was 13% compared to 2% burglary rate for liquor stores. Being a cash-only economy will also increase, again, home invasion, carjackings, robbery of individuals known to have marijuana products or money associated with selling it. Also, people that are going into these businesses to purchase it are also going to be they're going to have cash to purchase this. We can also anticipate that along with an increase in the number of individuals using marijuana, we'll see an increase in the number of motor vehicle-related offenses. In the year after the drug was legalized in Colorado, marijuana-related emergency room visits increased nearly 30%, as did traffic deaths involving marijuana. Along with the clear safety risk of more people on the roads driving under the influence, marijuana use poses unique enforcement challenges for us. Marijuana stays in your system longer than alcohol, making it difficult for a police officer to distinguish between someone that has marijuana in their system from prior use to being impaired.
Thank you.
Jim Brownsburg, Jim Friends, we want to thank you for having us here today and hanging in here for this late hour.
Thank you for having me.
You know, here's our speech here. I'm a commander of the drug unit in Boston Police Department for 27 years. And I've heard people here today say that legalization of marijuana is going to do away with the black market. As long as it's demand, somebody's going to supply it. Maybe for 14, 15, 16, 17-year-old in our community. And as the doctors have spoken here before, marijuana is a gateway drug as far as I'm concerned. There's many other people in the professional medical world feel that way as well. There are a host of other issues that come with this legalization, the number of plants that people will be able to obtain, 6 per adult in the household. If that's what I heard correctly, you have 5 or 6 adults in the house, 30, 36 plants. It's difficult, just camps kind of have all sorts of regulations and whatnot. The boy in college, 24 plants for kids in the house. Robbery-related issues that can result from this. People going through dispensary, from dispensary with cash, buying, or coming out of the towns of marijuana. Criminal element in our society, and not many of them pay taxes, so they're going to take what they can, and they're going to turn around and make a profit selling to people who can't buy it. Home invasions, we had one free drug in East Boston today, marijuana related, 3 guys keeping somebody's door, that gentleman's down in Western Hospital right now. 2 pretty bad people. That stuff won't go away. That's here to stay. So by legalizing it, it's just going to bring on all these other issues. We need to be allowed to do our job. As the DOP spoke earlier, and Chief Carmichael, very vocal about a lot of things I was going to speak about today, so I won't reiterate it. It's something we have to stay on top of. And you as a committee have a real big responsibility to step back. As cops, we have to react often in seconds. in this instance, they have a responsibility to legal Massachusetts, and you can step back and look at the big picture and say, you know what, we can wait. We can look at a lot more studies. We can look at what's going on out in other communities around the country, and can make an informed opinion based on all the data we have. It doesn't have to be done this year. It doesn't have to be done next year. There's a lot so in the interim. I think we save lives, and really where we stand. And one other thing I think we heard, I don't know if anybody here from South Hadley or Juciciary, I'm sure you know somebody here in the state also is butane honey oil is extracted from marijuana ash, between butane hash oil, butane honey oil. It produces a honey-like substance and becomes very explosive. Butane is used with it to extract it from the juveniles. Explosion also happened in October, which went to experiment a little over a year ago. In January, right, we got ourselves there, we drug unit, and we asked that maybe it's a lab out there. It's out there, out in West Roxbury, about a month ago. It's out there, very dangerous, and if we legalize this type of stuff, we get all these 18, 17, 16, 15, 18, 19, 20, well, the scientists want these out there, they're going to start, creating butane honey oil. That might be in campus dorm or somewhere else. And eventually somebody can die as a result of this stuff. So, there's a lot out there. Appreciate the consideration.
Thank you for your testimony. I think I appreciate it. Are there questions from members of the committee? Okay, thank you for taking the time to testify. Thank you for waiting through it. We appreciate having you testimony, well-informed testimony. Thank you. Doug Reed.
Okay, thank you. Thank you, Representative Fernandez and Senator Brownsburg and the Judiciary Committee. I'm here to speak in support of H4304 on alimony reform. Did you get the memo? I did get the memo. I just don't have it in the rest here if it's red. Good. You like that? But I did wear red back in 2011, an all-day hearing. I went to about 11 o'clock at night. But so essentially what I'm here to talk about is how it affects me, this particular legislation. Like the others that spoke here, we relied on the fact that that legislation was going to allow us to modify our divorces upon retirement. And I, at the time, had been divorced in 2009. Within weeks after that, I was fired from my job, or laid off, that is, and I filed a complaint to modify my divorce and my alimony payments. It took 2.5 years and $75,000, and also my spouse spent more than $75,000, in which this legislation in 2011 passed. And the new law was actually made a part of my complaint. The judge ultimately did make some modifications to my alimony because I was making less money, but would not rule on termination of the alimony upon retirement. Since then, my former wife has gone back to college, got the nursing degree. She's working full-time as a registered nurse. I also mentioned I'm a registered professional engineer, and so was my former spouse, too. So the judge ruled essentially that you should seek employment because you are actually qualified for 2 professional level jobs. So she has half of our retirement funds, which is happens when you get divorced. You split everything. She has half the 401k, I have half the 401k. When she retires, she's going to collect Social Security at my rate if she doesn't qualify for the top rate on her own. So we're going to have the same Social Security payments. We're going to have the same half of the same 401k. So why should I continue to pay alimony? She can retire, I can't. So what's really going to a trial for a divorce is quite a traumatic experience, not just an expensive experience. And so what I'd like to do by swift passage of this bill is give me some ammunition to sit down with my former spouse and negotiate a settlement now. Because the last thing I want to do is in 6 years when I reach retirement age to go through another 2-year expensive trial to fight it out, which is what will happen. By swift passage, I'm optimistic we can sit down and work something out and just avoid any legal costs whatsoever. So I urge the Judiciary Committee to support this and move through the process quickly.
Your attorney would probably tell you not to reveal your legal strategy.
Thank you.
There is videotape running, and comes up. William Harrison.
Sorry,
Thank you, William Harrison. Thank you.
do I have the right color on?
Close. I didn't write the memo, so you're fine with it.
Thank you for hearing me today. And I'll be brief, I'm sure I can get this out in less than 3 minutes. I'm a victim of the ruling, the SJC ruling. In August of 2014, I had a trial because I had turned 66 in May, so I went in to try to have the alimony ended. And while I was in the courtroom, Judge Shahegi looked over at my ex-wife's counsel and her and said, if I were you, I'd recommend that you go and make a settlement, because the new law stipulates that it ends when you reach retirement age 66. So I'm sitting there and I'm thinking, wow, this is really good. I finally got a shot at getting this thing to end. And so anyway, we went through the trial. She took everything under advisement, and everything went quiet. The ruling came out in January 2015. And probably about 3 or 4 months after that, Judge Shahegi made a ruling, which was really kind of vague, but she just dismissed my case.